Welcome back to Internal Affairs. I'm your host, Dr. Roy Taylor, where we examine the stories, cases, and controversies that shape modern policing in the United States. Today is episode 11, and we're diving deeply into one of the most significant Supreme Court decisions in the history of American law enforcement, Terry versus Ohio, which was decided in 1968. This case is foundational. It established what most every officer in America learns during their first days in the academy: the legal standard for a stop and frisk. It also raised questions about racial profiling and police discretion, and questions that remain unsolved and heavily debated today. But to understand Terry, you have to begin not with legal doctrine, but with a single veteran detective walking a beat on a cold afternoon in downtown Cleveland, Ohio in 1963. A detective who relied not on hunches, but on decades of experience watching people, reading their behavior, and responding to danger before it happened. This is the story of Detective Martin McFadden, of John Terry, of a weapons carrier named Richard Chilton, and of the Supreme Court decision that emerged from a 10-minute encounter on Euclid Avenue. It was October 31st, 1963, when the city of Cleveland was entering the late afternoon rush. Temperatures hovered in the mid-40s. Euclid Avenue, once called the most beautiful street in America, had become a busy commercial corridor lined with jewelry stores, men's clothing retailers, cafes, and offices. Detective McFadden was 62 years old, was working plain clothes. He had been a police officer for 39 years and a detective for 34 of them. His specialty was pickpockets, robbery crews, and shoplifters, criminals who typically worked in teams and often carried weapons. His experience, later emphasized by the Supreme Court, was not ordinary experience. Chief Justice Earl Warren described him as a veteran police officer with an unusual skill in detecting certain kinds of lawbreakers. That reputation mattered. McFadden wasn't looking for anything in particular that day, but years on the street had trained him to identify patterns, body language, pacing, eye contact, glances, and positioning that meant trouble. As Detective McFadden walked eastward along Euclid Avenue near the corner of East 13th Street, he noticed two men standing on the sidewalk. Their behavior caught his eye immediately. The first man was later identified as John W. Terry. The second man was Richard D. Chilton from Chicago. Detective McFadden saw Terry walk slowly down the sidewalk, about 20 to 30 feet, to a jewelry store. Terry paused there, looked inside for a few seconds, then turned and walked back to Chilton. They conferred briefly, then Chilton repeated the same pattern: walk to the store window, look in, return to Terry. Each man did this at least 5 or 6 times, alternating. The Supreme Court stated that the pair completed this pattern a dozen times. For Detective McFadden, this behavior was instantly recognizable. It mirrored the tactics of armed robbery crews he'd arrested for decades: surveillance of the target, repeated window checking, quiet conversation, return to the position, another walk, more conversation, nervous glances. They were casing the store. At least that's what McFadden reasonably believed. But there was more. As the men talked, a third individual joined them, Carl Katz, known to the police but uninvolved in the final charges. Katz spoke with Terry and Chilton briefly, then walked away. Detective McFadden watched for about 10 minutes. The Supreme Court described Terry and Chilton as engaging in behavior that would reasonably have led an experienced officer to conclude that criminal activity was afoot. Detective McFadden decided he needed to intervene, not to arrest, but to investigate. As any veteran police officer knows, that step is critical, a moment where experience, caution, and the potential for violence intersect. He approached the men, identified himself as a police officer, and asked their names. According to his testimony, Terry mumbled something unintelligible. All 3 men appeared extremely nervous. Their hands moved. Their bodies turned slightly away. Their shoulders and arms tightened. This behavior was subtle, but Detective McFadden had seen it before. These were pre-assault indicators, movements of people preparing either to fight or to reach for a weapon. Detective McFadden feared for his safety. He testified that the men were acting in such a manner that made me suspect they may have a gun. This moment is the hinge of the entire case. Detective McFadden ordered all 3 men to face the glass window of a nearby store. He then conducted what he described as a quick frisk or pat-down of the outer clothing for weapons. Let's be clear, this was not a full search. It was not an arrest. It was a frisk for weapons for the protection of the officer. As Detective McFadden later said, during the frisk of Terry, McFadden felt a bulge in his overcoat pocket. The Supreme Court opinion described it as a gun-shaped bulge. McFadden reached into the pocket and retrieved a .38 caliber revolver. He then frisked Chilton, felt a similar budge, and recovered another .38 caliber revolver. All the guns were loaded. He did not frisk Katz thoroughly, believing Katz was less involved, although this decision has been debated in modern training circles ever since. Terry and Chilton were arrested for carrying concealed weapons, a violation of Ohio law at the time. This is crucial. They were not prosecuted for robbery or attempted robbery. The charges stem solely from the weapons discovered during the pat-down. The case proceeded to trial in Cleveland Municipal Court. Terry's defense attorney moved to suppress the guns, arguing that McFadden's frisk was unconstitutional. The claim was clear. Detective McFadden had no warrant. He had no probable cause. Therefore, the search violated the Fourth Amendment. The prosecution countered. Detective McFadden had reasonable grounds to believe that the men were preparing for an armed robbery. He feared for his safety. A limited pat-down for weapons was reasonable under the circumstances. Judge Bernard Friedman denied the motion to suppress. He ruled that McFadden's experience justified the stop and the frisk was reasonable for officer safety. Terry was convicted. Chilton was also convicted in a separate proceeding. Terry appealed. The case eventually reached the Ohio Supreme Court, which upheld the conviction. Terry then appealed to the U.S. Supreme Court, arguing the entire procedure violated the Fourth Amendment. The case was accepted for review, and the Supreme Court had to confront a fundamental issue. Can a police officer detain and frisk a person based on reasonable suspicion, short of probable cause? This question had never been formally answered. Before Terry, the Fourth Amendment was mostly interpreted through the lens of probable cause. You searched someone if you had probable cause. You arrested someone if you had probable cause. Everything hinged on that standard. But Terry changed all that. During oral arguments that were held on December 12, 1967, the justices asked pointed questions. Can an officer pat down anyone they think might be dangerous? How much discretion is too much discretion? What is the difference between a hunch and a reasonable suspicion? Should courts defer to an officer's experience? How do we balance personal liberty with public safety? Can the police ignore obvious danger just because they lack probable cause? These questions force the court to create a new framework. On June 10, 1968, the Supreme Court issued its landmark decision. The holding, by 8-1 majority, the court ruled a police officer may stop a person if the officer has reasonable suspicion that criminal activity may be afoot. A police officer may frisk that person if there is reasonable suspicion the person is armed and dangerous. The frisk must be limited to a pat-down of outer clothing for weapons. Chief Justice Earl Warren authored the opinion. The court emphasized the stop must be justified at its inception. The frisk must be strictly limited to what is necessary for officer safety. The officer must articulate specific facts, not just a hunch. Experience matters in evaluating an officer's interpretation of behavior. Officer safety is a compelling government interest. This became known as the Terry Doctrine. The court introduced a new term now taught in every police academy, reasonable suspicion, which is a belief based on specific and articulable facts, together with rational inferences drawn from those facts. This is less demanding than probable cause, but more than speculation. The court created a balancing approach between the government's interest in preventing crime and protecting officers and the individual's interest in privacy and freedom from arbitrary police intrusion. Under this balancing test, Detective McFadden's actions were deemed reasonable. Justice William O. Douglas issued the lone dissent. Douglas argued that the majority had granted police a great power, more than what the Constitution allowed. He warned about authorizing searches without probable cause. He feared that reasonable suspicion would become a vague standard ripe for abuse. He argued that reducing the probable cause requirement was a dangerous erosion of the Fourth Amendment. Many of Douglas's concerns resurfaced during modern debates over stop and frisk programs. However, the Terry decision revolutionized American policing. It gave officers a legal bridge between voluntary encounters and full-blown arrest. It created two distinct actions: the Terry stop, a limited detention, and the Terry frisk, a limited pat-down for weapons. Terry stops are now part of daily police work nationwide. The decision has also sparked decades of debate. Racial profiling concerns, stop and frisk policies in cities like New York, questions about how officers articulate reasonable suspicion, the relationship between proactive policing and civil liberties. Modern law enforcement academies, including those I've run and instructed in, use Terry as a cornerstone. Identify reasonable suspicion, articulate observations, understand pre assault indicators, conduct safe, limited weapons pat downs, recognize constitutional limits. Terry has become synonymous with constitutional policing when done correctly and with abusive policing when misused. As a chief of police and expert witness reviewing hundreds of use of force and non consensual stop cases, here's what officers must take away from Terry. Number one, you must articulate your observation. Vague claims like, "you look suspicious," doesn't meet the standard. Two, officer safety matters, but it has to be justified. You can't frisk everyone you stop. The threat must be specific. Three, stop and frisk are separate legal actions. Reasonable suspicion of criminal activity does not automatically authorize a frisk. Four, experience matters, but experience must be tied to clear, explainable facts. Five, accountability and documentation protect both the public and the officer. Well articulated reports keep officers safe in court and ensure transparency. Six, Terry is a tool, not a license. It authorizes a limited, reasonable, safety based action, not broad authority to detain or search without cause. Terry remains one of the most important and most misunderstood casing in policing. That concludes episode 11 of Internal Affairs. Today we explored how a veteran detective's observations on a Cleveland sidewalk led to a Supreme Court decision that still defines boundaries of police authority and individual rights. If you enjoyed today's deep dive and want more episodes examining law, policing, and the cases that shape our profession, please subscribe and share this podcast with colleagues, students, and anyone interested in the intersection of law enforcement and the Constitution. Also, check out my book, Being a One Percenter, which is available on Amazon. I'm Dr. Roy Taylor. Stay safe, stay informed, and always remember, constitutional policing isn't just a requirement, it's the foundation of trust. Thank you for watching.